अब ये कुछ एग्जांपल है कि आप एक प्रोडक्ट को के लिए बहुत सारे इंटेलेक्चुअल प्रॉपर्टी के अधिकार के लिए आप फाइल कर सकते हैं। जैसे कि एप्पल का लैपटॉप है, तो एलईडी डिस्प्ले के लिए पेटेंट फाइल कर सकते हैं, बॉडी ऑफ लैपटॉप के लिए डिज़ाइन फाइल कर सकते हैं, एप्पल साइन के लिए आप ट्रेडमार्क अप्लाई कर सकते हैं, यूज़र मैनुअल के लिए कॉपीराइट डाल सकते हैं, और जो लेआउट है इसके लिए ऐसा डिज़ाइन में डाल सकते हैं। ठीक है? तो वैसे ये अलग एग्जांपल हो गया, आपको अलग हुआ। पहले का ये मतलब एक प्रोडक्ट है, लेकिन इसको आप अलग-अलग इंटेलेक्चुअल प्रॉपर्टी राइट से इसको डाल सकते हैं। ठीक है? ये फिर अलग डिज़ाइन हो गया। एक प्रोडक्ट है लेकिन मल्टीपल इंटेलेक्चुअल प्रॉपर्टी राइट्स के लिए आप डाल सकते हैं। ठीक है? तो आप एक सिंपल अप्रोच से अभी एक साइंटिस्ट बन सकते हैं। ठीक है? किसी प्रॉब्लम को आइडेंटिफाई करिए, उसको सॉल्व करिए और आप पेटेंट के लिए फाइल कर सकते हैं। तो ये सारी चीज़ें हैं। सो मैं जो कि ये सारे प्रोसेस सब 3 और 4 ऑफ के द्वारा वो बात नहीं किया जाता है। ठीक है? तो इन सारी चीज़ें हैं, इसके साथ ही मैं अपना स्लाइडिंग स्टॉप करता हूँ और मैं आपसे रिक्वेस्ट करता हूँ कि अगर आपको कुछ इसमें समस्या है तो आप पूछ सकते हैं। ठीक तो
थैंक यू सर।
पूछना तो आप पूछ सकते हैं, कोई दिक्कत नहीं।
किसी के पास कोई क्वेरी है तो सर से वो क्वेश्चन पूछ सकते हैं अपना माइक्रोफोन ऑन करके। If anybody want to ask a question, then you can.
हेलो, मैं audible?
यस
Yes, sir.
सर मैंने एक इंडियन पेटेंट फाइल किया था, कॉपीराइट फाइल किया था। क्या मैं वही इंटरनेशनल लेवल पे फाइल कर सकता हूँ?
यस कर सकते। कॉपीराइट कॉपीराइट तो यूनिवर्सली एप्लीकेबल होता है, टेरिटोरियल राइट नहीं है। कॉपीराइट इज अ यूनिवर्सल राइट। अगर आप ये पूरे जितने भी कंट्री जिन्होंने हेग एग्रीमेंट साइन किया है वो सभी कंट्री में ऑटोमेटिक चालू हो जाता है। आपको ये सेपरेट जैसे पेटेंट को हर टेरिटरी में फाइल करना पड़ता है, लेकिन कॉपीराइट का कोई जरूरत नहीं। इट इज यूनिवर्सल राइट। आपको दूसरी जगह फाइल करने की जरूरत नहीं है।
थैंक यू सर।
Anyone who want to ask question, then please ask.
Sir, I had one more doubt. Sir, what is the price for copyright and patent?
कॉपीराइट में 500 है, उसके आर्टिस्टिक वर्क के लिए 5000 एंड सिनेमेटोग्राफी फिल्म के लिए अलग-अलग, उसके लिए अलग-अलग फीस होती है। तो कॉपीराइट में आप कौन सी फिल्म में फाइल करना चाहते हैं? तो इसमें बताया।
Yes, and for IPR, sir?
पेटेंट के लिए।
Yes, sir.
पेटेंट के लिए अगर आप इंडिविजुअल हैं तो 100 1600 कॉमन में लगेगा, फॉर रिक्वेस्ट फॉर एग्जामिनेशन के लिए 1600 ये मिनिमम फीस होती है। इसके अलावा मान लीजिए अगर आपको कुछ बाद में अमेंडमेंट करना पड़े या फिर आपको कुछ उसमें फॉर्म फी वगैरह डालना पड़ता है, सब कॉस्ट अलग से लगता है। फॉर्म फी का स्टार्टिंग में फीस नहीं होता है, उसका फॉर्म 13 फीस होगा। उसके बाद मान लीजिए इन्वेंटर का नाम फीस होगा, तो मिनिमम फीस आपका 1000 का लगेगा। अगर आप इंडिविजुअल है और आपको भी
Okay, sir. Thank you.
Thank you, sir.
थैंक यू।
Thank you, sir. Your lecture is very useful and informative for us. In very summarized way, you explain about IPR, patent, copyright. Thank you, sir. I hope your lecture is useful and beneficial for all our participants. Thank you for accepting our invitation, sir.
थैंक यू मैम। ड्यू टू पॉसिबिलिटी ऑफ टाइम मैं भी ज़्यादा देर नहीं बता पाया, टाइम हो रहा था इसमें और
So, sir.
ठीक है।
Thank you, sir. Now our next speaker is here. Chaudhary sir, am I audible?
Yes, thank you.
Yes, sir. Welcome, sir. Now we start our next session. Our person of this session is Professor Ranjit Kumar Chaudhary, sir, Head and Dean, University Librarian in Charge, Department of Library and Information Science, School of Computation Science, Information and Communication Technology, Mahatma Gandhi Central University, Bihar. He have more than 30 years of teaching experience as well as administrative experience in higher education department. He supervised and guided more than 100 research scholars till now. He has published 30 research papers and wrote more than 40 book chapters in national and international journal and publication. He have attended and presented many papers in national and international seminar, conference, and workshop. I would like to cordially invite you to deliver your lecture, sir. Most welcome, sir.
Thank you, Swati madam. Thank you all organizing committee to give me an opportunity to discuss with you. I have sent a request from the dean sister at MGCUB. Please permit to attend. I would like to present from that email ID. मैंने एक रिक्वेस्ट सेंड किया है डीन सिस्ट के नाम से, CSICT के नाम से, उसको ऐसा कर लीजिए तो पेपर
Yes, sir. Okay, sir. Accepted.
Thank you. Today's topic is it's visible.
Yes, sir. Very
Okay.
visible.
Thank you. The theme is IPR. I would like to discuss about the copyright. So first, I would like to discuss with the definitions: literary works, artistic works, need Indian Copyright Act 1957, and copyright balance and role of library. Copyright is a general term that defines all the legal rights that creators have on their original work. Copyright facilitates exclusive rights to the creator and all the financial and other benefits associated with work. Bainbridge defines copyright is a property right which exists in various works, including literary works, artistic works, broadcast and recordings, etc. Copyright shows how the work is viewed and each author of a work and economic incentives to create new works. The literary works include journals, newspapers, reports, computer software, novels, poetry, databases, song lyrics, etc. Artistic works is painting, sculptures, drawings, photographs, architectural designs, applied arts, creative expressions, etc. Need. Copyrights is all about the protecting original works of authorship that are fixed in a tangible form or medium of expression. We need copyright to prevent the unauthorized access, to get license, to get financial benefits, to protect value of an author, to prevent from duplication, to get rewarded from the creativity and original right. The Indian Copyright Act 1957 is first its right in India started in 1914. Indian Copyright Act effect from the 1958 for amendments since 1983, 1984, 1994, 1999. The Act confers copyright protection in the following forms: statutory rights, economic rights, moral rights. Statutory right means it provides exclusive right to the original author for his work. It imposes a negative duty or penalty on unauthorized issues. Economic rights facilitates the author to enjoy financial benefits associated with the works. The author can earn royalty of assigning fully or partially rights to others. It may include adoption right, distribution right, rental right, reproduction and translation rights, etc. Moral rights protects non-economical interest of the author. A moral right grant an author the right to have his name kept on the work forever. Copyright balance and role of library. The libraries are major purchaser of copyright protected works, both analog or digital, and make such works available for patrons to browse, read, and use. Librarians and information professionals do, where possible, and to the best of their ability, protect against copyright abuse of the library material in collections. Thank you. Any question what you would like to ask?
Anybody want to ask any question? Then ask please, sir.
Hello, sir. Good afternoon.
Haji, good afternoon.
Thank you so much, sir. The session was very informative, but I have a query that you mentioned the literary works. It could be a poetry, it could be theme, or it could be an idea, right?
Right.
So in that case, I just wanted to know if you want to publish, if you want to get to like a book or supplemental guide, a small guide, a booklet of 50 pages or something. So in that case, how much it would cost for the filing of the copyright?
Filing, actually, copyright earlier, I think Dr. Kumar told there's a 500 rupees of fees for the registration and copyright.
Okay, but
I have discussed only on the how to protect your literary work.
yes, sir, yes, sir. But I was just getting an idea because if it is a small booklet only of, is there anything with relevant to its pages or something?
Okay. I will send you later.
Yeah, sure, sir. Thank you so much.
Any other? Thank you, sir.
Welcome. Thank you. Thank you all.
Thank you, sir. Your lecture is very informative. In very short, you explain us about copyright and IPR. Thank you, sir,
Thank you. Thank
for
you.
joining us.
Okay.
Now, our next speaker is here. Vajpayee ma'am, you can hear me? Yes, yes, I can hear you. Okay, let's start our next session. Our next resource person is Shreya Vajpayee, working as assistant professor in Dalgotis University, Great Noida, Uttar Pradesh. She has more than 3 years of teaching experience as assistant professor. She has pursued PhD from National Law University, Nagpur. She completed advanced course on patent organized by Lex Osmosis. She published 4 research papers in national and international journals. She attended and presented her paper in many national level conferences and seminars. Welcome, ma'am. I'd like to invite you to deliver your lecture.
Thank you so much, Ms. Swati, for inviting me and giving my profile, sharing my profile with everyone. A very warm good afternoon to everyone present here. I am Professor Shreya Bajpayee, working as assistant professor in Galgodia's University. First of all, I would like to thank Dr. Sudhavana Singh Nedam, Government College, Malajkhand, for inviting me as resource person to deliver a talk on IP, which is IP and on the theme intellectual property rights, creative India, and innovative India. So, and I would also express my thanks to Professor Dr. Vishwanath Maurya, Vice Chancellor, Chartered International Da Vinci University. I will start my session with the theme of with the theme of this international conference, which is innovative in intellectual property rights, innovative India, and creative India. So, like, eh, if I am very fine that Swati, I am delivering all my lecture in English, or like would you like to have use me a bilingual?
Okay, okay, you can.
No, no, I'm just asking you, like, what is the? Is it fine if I'm delivering in English?
Yes, okay, okay, you
Or,
can.
so,
If you use Hindi also, then it's also good.
or
English bilingual.
no problem, no problem. That's what I asked you. Okay, so like intellectual property rights. So I will be telling you about IPRs from our like IP lawyers' perspective. So inalienable rights. They are intangible rights. Now, what intangible means? Intangible means you cannot like you cannot touch that, right? Okay. In contrary to this, like I have a right on my land. Okay, so I can see that where my land is. Right? मुझे पता है कि वो land कहाँ पे है, मैं उसको देख सकती हूँ. I can see that land. Okay. But if I own a copyright, or if I own a patent, or if I own any intellectual property right, I cannot see it. Fine. So it is one of the basic we can say the characteristics of these rights are they are intangible in nature. We cannot see them. We cannot you cannot feel them. I will tell you I am having 50 patents, but I cannot see that patents. Okay, so they are intangible in nature. Thirdly, they give monopoly right to the holder. Okay, so any person who is having that right, it gives a monopoly right. Now, what does monopoly mean? Monopoly means that the right can be used only by that person, and it is given across against the whole world. Now, if I invented something, so I hope I am considering that the target audience are from science background, so I'll be explaining you in that manner. So, for example, if I am making any drug, okay, if I am like any company, okay, they came up with a drug. Now that drug, any person, the person that company has a right, monopoly right, that X company only has that right to sell that particular drug in the market. So no person other than that particular company can sell or can sell that formula in the market for 20 years. So this is the right which is being given to the holder of the IP or IP owners, a particular right to sell that. For example, if I will give you another example for a very niche example of trademarks, fine. So we have been to many a times to McDonald's. So McDonald's is selling their burgers using that golden arc M, okay, M mark. So wherever we are seeing that golden arc M, we are bifurcating, differentiated that these burgers are from McDonald's. Okay, there are other service providers also in the market. There are the Burger King is there. There are Wendy's, and there are so many. There are so many service providers in the market. But how we are differentiating it through using the mark which they are using to sell their services. So these marks are being used, or these sign is being used to differentiate their goods. So this right, the right which the McDonald's is having, or any other service provider is having, they are having this right only and only to be used by them. Nobody else can use it. Okay, and if somebody else is using, then what is the procedure in law? There is an infringement proceeding. You can sue that person in the court. Okay. So if any person is making any drug without a patented drug, without the permission or license of that particular company, then that person can be sued. Now, so this is basically what intellectual property rights means. Okay. Now, what is the need to have such rights what is the rationale to give such rights to individuals? So one important aspect here is these rights contribute in the economic development of the nation. So for the economic development of the nation, these rights play an important and crucial role in society. So first of all, here we need to here we have to think that these rights, the citizens should be given such rights so that they can protect their creativity. Okay, whatever they are making, like if I'm coming up with any invention, right? So I should be recognized. That should be recognized. Okay, and I should earn. I have spent my time. I have spent my energy. I have spent my intellect. I am spending my resources. So many things I am putting into for coming up with the time for inventing something. Okay, it took me 50 years to come up with the invention, and so society should recognize it. Society should reward me. Okay, now how society is rewarding and recognizing through IP rights? The state is recognizing the creativity and innovation of the citizens through rewarding through giving a monopoly right for, say, for example, patents having 20 years. So 20 years, this is a reward. This has been reward given to the inventor that okay, you came up with this invention. So you are being rewarded to like you can earn monopoly for 20 years. Okay, you can earn economic benefits out of it for 20 years. No one else can do that. If somebody is doing, you can sue that person in the court of law. All right. Apart from that, so this is how. Now, what is the reason of rewarding it? Again, the rationale of rewarding is so that people in the society can come up with new inventions. Fine. Now, new inventions. Imagine a society where there is no invention, like nobody is interested in inventing anything. So we can think that where that nation is. Okay. So there will be no development. Nothing would happen there. So in order to just encourage the innovations and creativity, the state, which is the government, is recognizing, which we call state, we call in a legal language. So I am using another term, that is government is recognizing these rights through giving through laws. Okay, so you have this right. If somebody like for this many years, if somebody uses it, you can sue that person. Okay, so this is a reward which has been given to the inventors, to the creators. For example, I am delivering this lecture, all right. So I have a right now in delivering this lecture also. I have a IP right, which we call it in copyright as performers right. So I am putting into, and now somebody, if somebody records this lecture and it starts selling it in the market, or that person starts earning economic benefit out of it, I can sue that person. Okay, this is because I am spending my time, I am spending my energy, I am delivering it, and I am sharing my knowledge with which I have been gaining through the past few years. Now I am the person who can earn economic benefit out of it. Okay, and without my consent, no person can earn it. So this is the reward which law is providing to the creators and to the inventors. Now, what is the reason for this reward giving? So that people can come up with creativity and innovation. So coming to the theme of this international conference, keeping within the themes of this international conference, which is Creative India and intellectual property rights, Creative India, Innovative India. So this is also one of the slogans of the IP policy. Okay, so for the first time, there was an IP policy which was formulated by the government. So 12th May 2016, Union Cabinet has approved an comprehensive national intellectual property rights policy. Fine. Now this policy basically lays down the roadmap plan of IPRs in India. This policy was framed by a think tank, and that think tank was led under the aegis of the think tank was working under the aegis of Justice Prabha Shri Devan. She was the former judge of Madras High Court. So under her guidance, this think tank was working on the policy, and in 2014 they submitted the draft of the policy, and finally they came up with they just came up with the policy in 2016, which the government which it was passed by it was announced by Mr. Arun Jaitley, who was Minister for Finance and Commerce and Industry during that time. Now, what was reason to bring this policy? Fine, this policy came up with the idea of Creative India and Innovative India, with the theme or tagline of Creative India and Innovative India. Now, the salient feature of this policy was that it brings a single platform, in order to bring in a single platform all IPRs. Fine. So people have a very different perspective. Like if the person is not from legal background, अगर कोई legal background से नहीं है, तो they will be telling that this book is patented. Okay, a book cannot be patented. Copyright मिलता है. Patents किस पे मिलता है? Inventions पे patent मिलता है. ठीक है, marks पे trademark मिलता है. But people will be just using these wrong terms, because this is not the problem of people, because this area is people are not aware about this area. Okay, so in order to create the awareness, in order to bring all the IPs in single platform, this policy was adopted by the government. Now, this policy basically focuses on the economic development and the innovative promotion. So, basically, according to this policy, intellectual property rights can lead to the principal. They consider this policy consider that the principal stimulator for creativity and innovations in a country. Nothing can be other than ideas. All right. So basically, one of the objective of this policy was there was a campaign. There was a campaign with a slogan: "Creative India, Innovative India." Okay. So this policy was formulated. There was objectives. There were 7 objectives. और हर एक objectives के साथ 22-23 guidelines थी how these objectives will be formulated, be achieved. तो उसमें से जो first objective था इस policy का was to to promote, to create awareness through outreaching programs and promoting the IP campaigns with the slogan "Creative India, Innovative India." Okay, so then it was there were so many policies was in action, and there is a Ministry for Commerce and Industry which is functioning to bring this policies into action. There are so many IP applications were framed, and so many efforts were taken by the government. Okay, now coming it into but there were some flaws in the policy which I do not agree with. Okay, so I will be sharing those. I would like to share those insights because we are aware of the policy. Okay, we can read through anywhere. We can if we log into any of the platforms of PSR India or wherever we want to PIB, the Public Information Bureau. में हम जाके policy we can see what is the policy, all right? So it is not a big deal to get policy, but what that policy should be like from an analytical mind. That what can be the problems with that policies. So I would be sharing those insights here. So usually there is a like 3%. Before policy, it was observed by the government that only 3% of the people were using patents, fine, registering patents by that time. Now, what was the conclusion from this policy was the think tank which formulated this policy. उनका basically take up ही यही था कि basic research is what that can foster an excellence in science and technology. ठीक है, तो basic research से ही we can excel in science and technology. So basic research now, अगर हम basic research की बात करें तो यहाँ पे जो basic research में so that just social sciences research है. Social sciences research would not take to the in technology or research will not help in the technological development in a country. So it should be the research fund should be spent in the areas of science and technology. So faculties who are in the position to generate good licensing incomes for the ideas, and basically they could be from science background and science and technology background. Okay, so what the sciences researchers can do like us, like we can contribute to the copyrights, we can contribute to other forms of IPs. But being a social science from a social science background, from a law, we cannot do any invention. All right, that by the scientists that the invention in order to protect it through the patents जो criteria है उसके लिए आपको सिर्फ और सिर्फ पेटेंट के थ्रू जाएगा. पेटेंट्स के क्राइटेरियाज है कि इट शुड बी एन इन्वेंशन, इन्वेंटिव स्टेप होना चाहिए, नोवेल्टी होना चाहिए, ठीक है, नॉन ऑब्वियसनेस होना चाहिए. सो दीस आर दी सम ऑफ द क्राइटेरियाज ऑफ पेटेंट. अगर ये क्राइटेरियाज नहीं है पेटेंट में, देन दैट कैन नॉट बी रजिस्टर्ड एट पेटेंट एज पेटेंट्स. ओके, अगर मान लो मैंने कोई इफ आई मेक एनी टाइम मशीन, ठीक है, नाउ आई एम मेकिंग दैट टाइम, आई एम जस्ट गिविंग यू एन एग्जांपल, फाइन, लाइक hypothetical example. Now that time machine that I am making it, I am inventing it, it should be non-obvious. Non-obvious means it should not have been think. No person should have think it before that. Okay, before me. That then this it would be a novel idea. Fine. वो कोई publish, वो किसी कहीं पे published papers में नहीं होना चाहिए, पहले से exist नहीं करना चाहिए. And there are so many criteria. वो industrial application होना चाहिए उसका. If I have invented with an innovation, अगर वो industrially applicable नहीं है, then also it cannot be then also it cannot be registered as patent. क्योंकि for registering it as patent, it is required that उसका industrial application भी जरूरी है. So there are criteria in the Patents Act in order to register it. So for that, a patent to be registered as a patent, it should fall into the criteria which have been provided under the Patents Act. All right. Now, coming up into the discussion of the investment into research, जो policy का like the policy which was drawn. So India, they established, and India itself has a very scientific power in the current world, if I talk about. So they came up, we are coming up with the fundamental research. We have to come up with the fundamental research. अगर मैं इंडिया के R&D के एक्सपेंडिचर को देखूं, कोट करूं इन परसेंटेज ऑफ द ग्रॉस जो जीडीपी, ठीक है, तो जीडीपी के रिस्पेक्ट में अगर मैं इंडिया का लाइक इफ आई रेफर टू एनी ऑफ द रिसर्च जो डेटा है, रिसर्च पब्लिक फंड्स इन्वेस्ट होते हैं, दैट इज वेरी लो, इट इज 0.6% ओनली, ओके, इन रिस्पेक्ट टू अदर कंट्रीज. अगर मैं डेवलप्ड नेशंस की बात करूं, जैसे यूएसए has 2.8%. So उनका जो जीडीपी है वो 2.48% दे आर इन्वेस्टिंग इनटू रिसर्च एंड डेवलपमेंट, ठीक है. जर्मनी की अगर मैं बात करूं तो इट इज 3.09% अपने जीडीपी का वो उस पे इन्वेस्ट कर रहे हैं. जापान में दे आर इन्वेस्टिंग 3.26%. So these are South Korea, maximum 4.81%. Israel, they are investing 4.95% of GDP in the research and development. So the reason why they are they are excelling in the technological development, ठीक है. अगर मैं यूएस बात करूं तो यूएस हैज एन एक्ट जहां पे जो यूनिवर्सिटीज है, if they are if there is a law, there is a legislation of the universities come up with any ideas or any innovative ideas or creativity, they can earn royalty out of it, though it was from a public fund, ठीक है. अगर मैं public fund से, if I am somebody is providing me public fund, okay, university is granting, UGCs are granting the public fund, doing research out of it, I can own a patent over that, though I didn't spend my money, I spent my energy, I spent my time, I spent all my things, but I didn't spend my money, it was the public money, alright. But then also universities can earn royalties out of it. We in India are lacking such laws, okay. Now what is the reason, what is leading to it is the less like innovative ideas are less, okay, because the reward which people should be giving, it is not guided in that manner, okay. Another thing is that जो public funded research results हैं, अब एक यहाँ पे critically policy पे बात कर रही हूँ ना, जो IP policy 2016, क्या talking about that. So IP policy is like if somebody is earning from the public fund research result, now that is public money, public से आप double taxation नहीं ले सकते. First the person is giving the tax through public money, public funded money, and then जब वो consumer बन रहा है तभी भी you are tax from them, okay. So this is another lacuna in this policy, that the public funded money की जो royalties है, if there is any research coming up with the public funded research, there should be some tax benefit, okay, provided to the citizens, because public is one time giving, the citizens are giving taxes, उस tax को आप use करके research results लगा रहे हैं, research के results लगा रहे हैं, and then जब अभी वो public consumer बन रही है, then also you are taking tax from them. So this is another take up from the another take up from this research from like lacuna in this policy. And so we have the other countries, जैसे कि we have patent system, ठीक है. अब patent system के साथ आपको पता है there are so many criteria to register patent, and there is hell number of procedure to register or time taken procedure. So दूसरे countries they are following utility models. India में utility models का concept नहीं है. Utility models is just like a small patents जिसके इतने criteria नहीं हो. If India is adopting that model into their IP regime, it would be better for, जैसे if we know that in rural areas या villages में people come up with so many, जैसे MSMEs हैं, और like there are so many medium sector industries, they come up with ideas, okay. So that can be protected through utility model. अगर वो पेटेंट के strict norms को नहीं follow कर रहा है, तो फिर that can be protected through utility models. But India does not have the provision of utility models like other countries like US. Another thing is India also likes lacks legislation on trade secrets. Fine. We in India, we are like a repository. Indian citizens have so many knowledge developed traditionally from generations to generations. Like we know from hundreds back that haldi it can be used as an it has a anti-healing properties. Okay, neem has antifungal properties. This is known into Indian people from since ages. Okay, since 100 years back. So, but now also now US what US people did they patented that a particular formula. So this was a question. The traditional knowledge which we are having, we are a repository of traditional knowledge, but we do not have any law which is protecting it. A sui generis law, a law of traditional knowledge through which we can protect it. We have some defensive protection. ठीक है TKDL है, Managed Traditional Knowledge Digital Library, जहाँ पे documented है, but we do not have a law to protect it. Okay, so these like some of the areas the policy which the policy is stressing into is the policy for promoting utility models, for promotion of utility models, so that we can come up with the innovative ideas from even if they're not falling to the strict like lines of patents, they're not following the strict lines of patents. Apart from that, we should also have some uniform legislations on trade secrets, also for traditional knowledge, especially the medicinal sector, the cultural sectors and culture including traditional medicines. We have some rights into the scheduled tribes and other traditional forest dwellers act, Forest Act 2006 का जहाँ पे community rights है that the right holders can ensure preservations, or if somebody is disrupting or affecting their cultural heritage, then they can sue that for the right isn't provided to those people in the Forest Dwellers Act, Scheduled Tribes and Forest Dwellers Act. Fine, there are copyright legislation के थ्रू आप कुछ हद तक folklore जो होते हैं, folklore of traditional people, you can protect it, but not exactly, fine, because it should be documented. Copyright का एक सबसे feature है that it should be published. Fine. So many of the traditional cultural expressions are not published. Like we would be hearing from our older generations उनको याद होता है, but they don't document it. Okay, बहुत सारे knowledges ऐसे होते हैं जो we will be having our family knowledges that should be curing many diseases. Okay, but they are not documented. Okay, so they're not published. Okay, so they are being passed on from generations to generations among the community. So there are so many cases of Aroki Pitta plant, and but I am restraining myself to here with this act. So this we have geographical indications also. Geographical indications like one of the traditionally goods can be protected through geographical indications. Fine, for example, Hyderabadi Halim. Okay, Hyderabadi Halim can be protected through geographical indications. But the cultural practices, what is being involved in making Hyderabadi Halim cannot be protected. Only that good can be protected. The cultural practice, how it is being formulated, how it is being made, and all those things cannot be protected through the law. So there are some lacunas in the existing legislatures, which this policy is also not addressing. So like I would stop here. I think I have exceeded my time, which has been provided to me. So any questions?
Anybody want to ask question? Anybody?
What is the duration of protection granted by patent for a product? Yes, it is 20 years. Okay. for any invention according to the Patents Act 1973, अगर कोई आप पेटेंट रजिस्टर कराते हो तो आफ्टर जिस डेट को आपने एप्लीकेशन फाइल किया है, ठीक है, उस डेट से आपको 20 इयर्स का टाइम ड्यूरेशन मिलता है that monopoly right is being given to that person, ठीक है। 20 इयर्स के बाद that particular invention comes into public domain, उसके बाद आप उस पे पेटेंट आप उसको अपने मोनोपोलाइज्ड प्राइस पे नहीं बेच सकते हो। that particular invention or any drug in case of medicines, it comes into public domain. We might have heard about generic medicines. India is one of the leading producer of generic medicines across the globe, ठीक है। अगर हम कंट्रीज की बात करें in across the globe, India is one of the leading countries who make generic medicines. Now once the medicines which are come falls into तो दिन से पेटेंट हट जाता है, 20 years हो जाते हैं, तो फिर then they comes into the public domain। इसलिए आपने सुना होगा कि generic medicines are cheaper in price in comparison to the medicines which are being provided like the patented medicines. That is why the price differences. No, patents cannot be renewed. There is no provision in the law to renew patents. What you can do is you can add up. Like I made a medicine with XYZ components. Okay. Now if I am adding a component, now XYZ plus A, if I am adding any component, and then again patent office will test to the efficacy of that drug. Okay. अगर मैंने A component ऐड किया है तो A component क्या efficacy है एक component की, अगर वो प्रूव हो जाता है थ्रू द पेटेंट ऑफिस एग्जामिनेशन, तभी वो वापस से like it can be again patented, but it should be new invention, ठीक है, वो एक्सपायर आर्ट में फॉल नहीं होना चाहिए। थैंक यू।
Any queries? Any other?
Hello, madam.
Yes, sir. I can hear you.
I'm Professor Dr. Manoharan. What is IPR status in India?
What is the
IPR status.
IPR? So we have laws like before
Status
starting
when, India when compared to world level.
world level in comparison to world level. I gave you the data.
Thank you,
Like if the data, I hope you're talking about the registration, right? Registration of IPs, or you're talking about the status of, like, we have rights, we have legislations. So we have Patents Act which protects patents. We have Copyrights Act which protects copyrights. We have Trademarks Act which protects trademarks. We have GIs Act which protects GIs. But there are all these laws are made through TRIPS. Okay, we have a standard legislation TRIPS at global level, और TRIPS के accordance, in order to follow the TRIPS agreement, हमने अपने laws, Indian laws को TRIPS के accordance में बनाया। So TRIPS is regulating the IPRs across the, like, it's an international legislation, जिसे international standards में बनाया गया, and उसी के provisions को in order to give the extend the domestic framework, to make the domestic framework, we have these legislations in India because India is party to TRIPS. ठीक है, इंडिया entered WTO in 1994, तो इंडिया पे obligation आ गया कि the moment इंडिया WTO में हुआ, इंडिया को ट्रिप्स के obligations फॉलो करने पड़े। तो ट्रिप्स के obligations जैसे इंडिया को फॉलो करने पड़े, उनको अपने जो आईपी लॉज है, उनको जो जिनमें लॉज एग्जिस्ट नहीं करते थे उनमें लॉज बनाना पड़ा, जहाँ पे लॉज एग्जिस्ट करते थे वहाँ पे उनको ट्रिप्स के अकॉर्डेंस में लाना पड़ा, in order to bring the in harmony to TRIPS. So we made our laws accordingly. Not we, I am talking about Parliament. So
Okay, thank you. Thank you, madam.
thank you.
Any other queries?
Yes, I think somebody raised his hand.
You can ask.
Somebody I just saw raising hand. If you have any query, you can ask or you can post in the chat box. Yes, Gayatri, I believe. Gayatri. Gayatri ji, can you hear me?
Gayatri ma'am, you can ask. Okay ma'am, I think there's no query.
All right. If any person is having any query, you can provide my email ID. You can write to me also. You feel free to ask any query. I will also replying on emails. All right. It's not an issue.
Of course, ma'am. Thank you, ma'am. Your session is very informative and useful for us. I hope that this session increases awareness about intellectual property right among all participants and students. Thank you for joining us, ma'am.
Thank you so much.
Wait for a minute. Next session is vote of thanks. You will stay with us.
Okay.
Sure.
That's it.
Now I want to invite respected principal sir, Dr. Dhruv sir, for vote of thanks.
Thank you, Swati. Special thanks to Professor Vishwanath Maurya sir, our chief guest, and Professor Ranjit Kumar Chaudhary sir, Mr. Kumar and President हमारे साथ में जो है मैडम श्रेया वाजपेयी मैम। आप सभी जो हमारी अतिथि वक्ता, बहुत सुंदर विचार आप सभी का हमें सुनने मिला और हम तो सौभाग्यशाली हैं। मेरे ख्याल से सबसे पहले तो मैं मेरे इस कॉन्फ्रेंस के माध्यम से बहुत सारे कॉलेजेस के हमारे प्रोफेसर साथी जुड़े हैं और हमारे विद्यार्थी जुड़े हैं। निश्चित ही हमारे चारों वक्ताओं ने हमारे जो व्याख्यान जिन्होंने दिया है, बहुत ही सुंदर व्याख्यान, और इस व्याख्यान का पूरा फायदा हमारे प्रोफेसर को मिला है और मेरे विद्यार्थियों को मिला है। व्यक्तिगत तौर पर मैं सभी लोगों को मैं खुद सुना हूँ और मुझे बहुत अच्छा लगा कि बौद्धिक संपदा अधिकार पर जो है इतने उनके वेरियस अलग अलग क्षेत्रों पर जो है आपने इतनी अच्छी सुंदर जानकारी दी है और एक हमारे ज्ञान में जो है नई अभिवृद्धि की है। इसलिए मैं बार बार ये कहना चाहूंगा कि स्पेशली जो है आप चारों लोगों को बहुत बहुत महाविद्यालय की ओर से धन्यवाद और आरों का बहुत बहुत आभार। साथ ही आप सब तक हमारा मार्ग जो है प्रशस्त करने वाले हमारे जो चीफ एडवाइजर है प्रोफेसर अनिल डी सहस्त्रबुद्धे सर, साथ ही मैडम स्वाति जो कि हमारे केमिस्ट्री डिपार्टमेंट के प्रोफेसर है, आप सब तक हमें पहुंचाया उन्होंने, उसके लिए मैं स्वाति मैडम को धन्यवाद कहूँगा। और साथ ही साथ एक बार पूरा हमारे जितने भी पार्टिसिपेंट हैं जो हमारे साथ आज जुड़े, जिन्होंने इस कॉन्फ्रेंस को जिन्होंने सफल बनाया, उन सबका मैं धन्यवाद करूंगा, उन सबके प्रति आभार व्यक्त करता हूँ। आप सबका बहुत बहुत धन्यवाद।
Thank you, ma'am. Thank you all participant. मैं पार्टिसिपेंट से स्पेशली मैं बोलना चाहती हूँ कि कुछ टेक्निकल इशू रहा जिसके कारण से बहुत सारे पार्टिसिपेंट्स को हम ज्वाइन नहीं कर पाए। ये है कि हम नेक्स्ट सेशन में जब भी हम कोई प्रोग्राम ऑर्गेनाइज करेंगे, हम यूट्यूब पे उसको शेयर कर देंगे ताकि टेक्निकल इशू के कारण हमारे कोई सेलेक्ट ना रहे प्रोग्राम में जुड़ने से। तो फीडबैक फॉर्म मैंने ग्रुप में डाल दिया है, मैंने कमेंट्स बॉक्स में दिया है, दोनों ही फीडबैक फॉर्म आप सब भरिएगा। और लास्ट में मैं सब पार्टिसिपेंट से अनुरोध करती हूँ कि वो अपना कैमरा ऑन करें ताकि मैं एक स्क्रीनशॉट ले सकूं। एंड थैंक यू मैम। थैंक यू। सब अपना कैमरा ऑन कर लेंगे।
काम है उनका हमारे यहाँ गेस्ट फैकल्टी वाले जो है ना, उनका जनवरी का जो ज्वाइन की है और इस तरह जो पेमेंट है तो फिर टेक्निकल इशू होता है। वहाँ पे फिजिकली जाकर कर सकते
Thank you everybody for joining us. Thank you so much. Now I can stop. Okay, thank you. Now I can close this meet. Thank you.
Pics on group, ma'am.
Thank you so much.